Everyone, this is Ruby Powers with Powers Law Group, and today we're talking about U.S. employment-based green card options. So I'm a managing attorney with Powers Law Group, and the firm is 14 years old this month. We're excited, we're celebrating, and I'm board certified with the Texas Board of Certification in Immigration and Nationality Law for the last decade. I wrote a book about law practice management. I'm a professor on law practice management and also small business. And we are full service immigration law practice. So that means we help individuals with employment-based, investment-based matters, inadmissibility waivers, removal, immigration, court, litigation, asylum, humanitarian, you name it, immigration, U.S. immigration, we do it. So anyway, today I want to talk about the green cards and how you can obtain them through employment-based options. And this is a really big topic for many individuals. We're seeing a lot better climate under the Biden administration, pro-immigrant, and this is giving a lot more opportunities for individuals to be able to find a pathway to stay in the United States long term. So green cards are legal permanent residency for employment-based immigrants. There's lots of different potential ways. You know, when I do these conversations, consult, usually when we're talking to a person in the very beginning, there's the conversation of what plan A, B, and C. Plan A is like what gets you here to the country for a little while, and sort of a pathway to maybe B, and then C is like trying to get the legal permanent residency. And so it takes a while. It takes a lot of strategy and planning. So there's different preferences, and we'll go through all of those. Now, if you obtain the green card inside the country while you're here, that's called adjustment of status. If you obtain it while you're outside of the country, that's called consular processing. And it's important to note that there's just so much demand and interest right now that some people, the visa availability is taking a lot longer. So you have to look at the visa bulletin every month and scope that out. And so I'll just say, like, I had a consult with somebody and they talked to us back in a few months ago, and then about 5 months ago, and then they came back and I was like, well, the visa bulletin's like even worse than it was before, and it's taking longer, and you're only so much availability on your initial visa. And so that goes back to that A, B, and C type of thing that we're thinking about, like how much time do we have and what are our options going to be? And we're having lots of conversations with clients as to what happens if we don't have enough time for them to be in the US and we have to do consular processing, or can we recapture time? So if you're in the US and you're eligible for a legal permanent residency under EB-1, 2, or 3, it's the 485 that adjusts the status from your visa to legal permanent residency. And there's lots of things to consider. Your visa has to be current. You need to have no other inadmissibility issues. And if you do, you need to be eligible for waiver for it. You need to be inspected, paroled, admitted. You need to be in a visa that's current at the time of the filing. So like you're saying on an H or an L, for example, it needs to be current when you file. You need to have that legal entry. And it depends on if there is a job offer requirement or not for that type of case type. With a national interest waiver, you don't need to have a job offer. But these are some of the things you have to consider. So you really need to have an experienced immigration attorney helping guide you through this process. And the other thing is, like, you might have had your company help you do the visa, but now maybe you're doing a national interest waiver on your own. And we help represent small, mid-sized law firm companies, but we also help the individual, self-petitioning individual. So there's bars to adjustment of status, and if you have certain violations, misrepresentation and fraud, or unlawful presence, these things, or if you entered illegally, things like that. So these are all things that we have to review and analyze. The other thing is that if the visa is available, you most generally can include your legal spouse and your unmarried children under 21 of age. Now, you have to look to see, like, is the 45 or consular processing going to be approved before the child turns 21, or are you eligible help freeze the age of the child so that they can still qualify. But I mean, honestly, besides the whole A, B, and C thing about trying to get that all figured out, the children are probably the most stressful in this whole process, because by the time the resume is all built up and the people qualify for certain things, or the company's willing to petition, then the children are getting older. And if they don't make it on their green card in time, then they'll have to usually go off and be on F1s, or maybe leave the country and try something on their own, or maybe they can do an E2. But this is a huge part of the conversation. Now, the other thing that can be quite stressful about this is the timing of things, is like, when is the visa going to be available? So let's say the visa is available, but you only have a couple months left on the visa, the L or the H or something. Well, if you can file the visa, the immigrant visa I'm speaking of is available, then you can file the 485 if all things are eligible and qualify. But then the 485, then it'll take a little while for the work authorization to come in. There's different schools of thought. Some people say as long as you have the work authorization in your hands, then you're fine, even if your your underlying visa has expired. But as long as you were in status at the time of the filing the 45 and the visa was available, and then as soon as you get the work authorization, you're able to work. Some are a little bit more conservative on that approach, but it's also important to note just the likelihood of approval. But for the most part, a lot of people just move forward with working as soon as they have the work authorization. But anyway, these are just some things to consider. And also, travel is really critical to pay attention to that when you're in that transition phase, especially if your underlying visa is about to be expired. Now, so we'll just run really briefly through this. The first preference, EB1. So this is the extraordinary ability, so science, arts, education, business, or athletics, outstanding professor or researcher, or certain multinational executive or manager. So there, where we see the multinational executive or manager is when the individual is on L1A, either a new office, or they own the business, or they're with their company as an L1A. And as long as you can prove that they're managing a team or a department successfully, and they meet all the other qualifications, then this we have a lot of success in that. The EB2, this is when professions holding advanced degrees or have exceptional ability. And so exceptional ability meaning degree of expertise significantly above that ordinary encountered in the science, arts, and business. And requests for national interest waivers. The national interest waiver, you do not need a job offer. You're able to move the field forward in the space that you are in, and there's a lot of qualifications that you must prove that you qualify there. We've seen a lot of success with national interest waivers since the Biden administration, even more so, and a lot more interest. And there's also a big focus on AI and technology. Now, there was a executive order announced really recently on that subject as well. But I will note, they do have premium process for a lot of these different areas that they didn't have before. But because there's a backlog on some, like EB2, for example, the national interest waiver, even some people say there's no point in doing the premium processing because the wait time still is taking as long as it is. But some people like to have that peace of mind that it's approved. So there's different schools of thought. I think it's applicable to the case, which one you go forward. EB3. So this is different categories. Skilled workers have a minimum of 2 years training or expertise, and the job is not temporary or seasonal. Usually all these things that I'm mentioning have a little bit longer wait times, especially depending on what country the individual is a national of or will be under the chart, the visa bulletin. Professionals are those who require at least a U.S. bachelor's or a foreign equivalent, or other workers like unskilled labor requiring less than 2 years of training. So people can get legal permanent residency in these spaces, including the unskilled labor. And there actually are a huge shortage of people in that space. So sometimes the visa can take a little bit longer. And it's important to note that if you have a green card pending, it doesn't give you the right to be here in the United States while this is pending. In fact, one of the cases we did for, like a teacher of a like a little, what's it called? Like a daycare school. The visa was taking a long time and her underlying visa had expired. So she had to go back home. And then eventually when the visa was available, she was able to bring in her spouse and children through consular processing. So EB4 covers a lot of other categories, religious workers, special immigrant juveniles, members, you know, a lot of different specific ones, Afghan or Iraqi translators, interpreters, Afghans who are employed by the US government or National Security Assistance Force, certain broadcasters. Um, there's sort of like a hodgepodge of a lot of different categories here in the EB4. You have to really watch the visa bulletin and the availability, because you could run out of time here in the country, like I've already mentioned, and need to have another underlying visa because you need to be in status for employment-based green card at the time of the filing. And if your visa is taking too long, you might have to leave the country. And just a side note, like H's and L's have a certain amount of time that you can be in the United States. But there are times with an H you can extend it if you have a perm pending, and the L's, at H's and L's, you could recapture time if you are outside the country. So when you do that last extension, you could ask for more time on your H and L, and that could buy you a little bit more time to be here in the country. We're doing that for lots of clients right now, because of these delayed processing time or visa bulletin, visa availability. But otherwise for H's and L's, otherwise you have to stay out of the country an entire year to restart that clock again. And sometimes that could work for some individuals who are working for a company and want to maybe have a national interest waiver pending. But those are a lot of considerations we have to think about. The EB5, so this is the one where you have a certain level of investment, that for either you have to make investment in a commercial enterprise or plan to create or preserve 10 permanent full-time jobs for qualified U.S. workers. There's a two-part process with the filing, and it can take a few years for the whole thing. But this again includes spouse and unmarried children under 21 that are eligible for this. And there's a lot of different changes and updates in this, but this is another great opportunity based on investment into the country, in the United States. So that was a brief overview of employment-based immigration options for legal permanent residency. My name again is Ruby Powers. I speak Spanish and English and sometimes a little French and understand a teeny bit of Turkish. But my other associates, Cynthia Million, Larissa, and we have other attorneys on staff as well. I have a myriad of languages from Russian, Ukrainian, Spanish. We also have other interpreters on staff or on availability. We send out information normally in Spanish, English, and sometimes Turkish in our newsletter, as well as we have content on our TikTok, Twitter, X, Instagram, LinkedIn, Facebook, website, all of the above. We're celebrating our 14th anniversary. So excited to share that with our staff, clients, community, and just being a part of everyone's lives over these last 14 years. It's been great, making an impact. And we do have a lot of experience in employment, investment, immigration. But what also makes us special is that we see the big picture, having had experience in other areas of inadmissibility, waivers, and so we can help, and family, we can give guidance on the big picture. So thank you so much for watching, and we'll provide this as well in Spanish, but feel free to share, give us a call, reach out to us if you have any questions. Thanks.